Okay, I'm going to read Sugarland Industries, Inc. versus Thomas from the Supreme Court of Delaware of 1980. Mr. and Mrs. Harris, shareholders in Sugarland Industries, retained an attorney to represent them when they learned that the Sugarland board was considering a sale to White and Hill of substantial acreage referred to as South Track. The company owned for $23.8 million. They believed the price was inadequate, partly as a result of Harris's effort. Another bidder, RSC, offered to purchase the land for $27 million. Nonetheless, the Sugarland board continued to favor the land, the lower White and Hill offer. The Harris's ultimately initiated derivative suit, and the chancellor ordered that the board entertain competitive bids for the property. Among the sealed bids, Hines was the winner, offering approximately $32.2 million for the property. Hines pushed to acquire the adjacent North Track, which led to more sealed bids, and once again Hines won, having bid $1.25 million, more than the next highest bid. Thus, both tracks were sold to Hines for $44 million. The attorney representing Mr. and Mrs. Harris sought a fee from Sugarland. It is crystal clear that from the record that the services the petitioners benefited Sugarland to the extent of the difference between the White and Hill offer of $23.8 and the $27 million, which was submitted by RSC. But how one should view the amount received by Sugarland in excess of the $27,000 is not so clear. Petitioners had sought the best price obtainable, and but for their initiative and success at the injunctive stage, Sugarland might not have received anything over the White and Hill offer. Thus, there is, as we've noted, some cause and effect between what petitioners did and the ultimate price received. The petitioners are attorneys seeking compensation for services rendered in litigation. They are not brokers or real estate agents seeking a commission or a percentage of sale price for having produced a buyer, and how much anyone would pay, at least in excess of $27 million offered by RSC, was a circumstance neither caused nor influenced by petitioners. The highest offer eventually made was in it something in the nature of a windfall. Petitioners here cannot take full credit for the price which Hines was willing to pay for both tracks. In making the award, the chancellor used a 20% in benefit factor. That seems reasonable to us when applied to the difference between the respective offers, but for the reasons we have discussed, it is unreasonable when applied to the amounts paid by the buyers in excess of $27 million. We have held that petitioners are entitled to some credit for the benefit received in excess of that sum, and in view of the circumstances, any percentage is arguably fair or not, depending on one's point of view. In our judgment, based on the various factors we have noted, compensation at a rate of 5% of the benefit achieved is fair and would be applied to the additional benefits Sugarland received from the sale of both the North and South tracks, given the fee, which that percentage generates about $573,000 in all. We conclude that it is reasonable and perhaps generous compensation for significant skills and expertise which petitioners demonstrate in identifying an adequate price for the tracks and stimulating the competitive offer from RSC and quickly initiating the litigation and successfully carrying it to a conclusion against highly competent counsel, and thus opening the door for entry by the Hines interests with their offers. A fee was awarded of $1,213,609, reflecting 20% on the difference of the White and Hill offer and the RSC offer, and a 5% of the improvement in the sales price reflected via competitive bidding. Background note on the award of counsel fees to successful derivative action plaintiffs. The derivative action constitutes a major legal bulwark against managerial self-dealing. As a practical matter, this means that the rules governing plaintiffs' legal fees are critical to the operation in the corporate system because they view shareholders would pay out of their own pockets the attorney's fee for a suit which is brought in the corporation's behalf and will benefit all shareholders with only a slight and indirect benefit for the plaintiff. Very few derivative actions would be brought if the law did not allow the plaintiff's attorney to be compensated by a contingent fee payable out of the corporate recovery. As a conceptual matter, the award of counsel fees to successful plaintiffs in derivative actions has been justified by several overlapping rationales, none of which is unique to derivative actions. The most important of these is the common fund theory, under which the plaintiff who has successfully established a fund under the control of the court, from which many besides himself will benefit, may recover his counsel fees out of that fund. The state, as stated in the seminal case of Trustees versus Greeno, which is an auto case of 1881, to deny an allowance for fees of such circumstances would not only be unjust to plaintiff, but would give to the other parties entitled to participate in the benefits of the fund an unfair advantage. This theory was later elaborated under the heading of the substantial benefit. Or common benefit theory, to cover cases where the plaintiff had not brought a fund into the court's control but had established a right to a fund from which others would benefit. See Sprague versus Taconic National Bank of 1939. Eventually, the common benefit theory was extended to cover cases involving establishment of non-pecuniary benefits. Another basic rationale for the award of attorney's fees to successful plaintiffs in derivative actions is the private attorney general doctrine. The plaintiff's counsel fees should be awarded in appropriate cases to encourage the initiation of private actions that vindicate important legal policies. And that's from Newman versus Piggy Park Enterprises, Inc. from 1968. In the corporate area, this doctrine is important chiefly as a reinforcement to the common fund or common benefits theory, particularly where the benefit is not pecuniary. For example, Mills versus Electric Autolite Co. Plaintiffs who were former Autolite shareholders alleged that defendants had violated the proxy rules in connection with the merger of Autolite into Mercantile. The court held that plaintiffs were entitled to summary judgment on the merits. It then went on to award interim counsel fees, although it recognized that if on remand the merger were found to be fair, there might be no feasible way to remedy the violation and therefore no economically measurable benefit to either Autolite or its shareholders. The opinion began by attempting to bring the case into the common benefit rule. In many suits under 14A, it may be impossible to assign monetary value to the benefit. Nevertheless, the stress placed by Congress on the importance of fair and informed corporate suffrage leads to the conclusion that in vindicating the statutory policy, petitioners have rendered a substantial service to the corporation and shareholders. However, the court then seemed to shift rationales by stressing that the action conferred a benefit on the subsector of the public, that is, shareholders as a class. In Alyeska Pipeline Service Co. versus Wilderness Society, 1975, the Supreme Court held that in the absence of statutory authorization, attorney's fees may not be awarded on the private attorney general theory in suits brought under federal statutes. While the opinion left the common fund theory and its derivative, the common benefit theory, undisturbed, and cited Sprague and Mills with approval, it is open to question whether the Supreme Court would again go as far as it did in Mills in determining what constitutes a benefit for these purposes in a suit brought under federal law. Consisting with these rules, it is now well established that attorney's fees can be awarded to a plaintiff on the basis of common but non-monetary benefits, such as a corporation's agreement to change its governance structure as opposed to the creation of a common fund. This rule has two important implications in derivative actions. First, it is often difficult to attribute any realistic value to non-monetary benefits. As a result, in such cases, attorney's fees usually are measured under the lodestar method, even by courts that employ the percentage of the benefits test in common fund cases. Second, the rule that a plaintiff's attorney is entitled to a fee for producing a non-monetary benefit opens the door to the possibility of collusive settlements in which the real defendants in the derivative action, the directors or officers, pay little or nothing. The corporation agrees to a change that is largely cosmetic. Plaintiff's attorney and the corporation join hands to inflate the importance of the change, and plaintiff's attorney is then paid a fee that is supposed to be justified by that importance, but is really a bribe to drop the case. The real defendants are happy because they get a release, although they have paid little or nothing. Plaintiff's counsel is happy because she gets a very nice fee. The shareholders aren't unhappy because they don't realize what happened. If they did realize what happened, they would be very unhappy. This doesn't mean that every settlement involving only a non-monetary benefit is exclusive. Nevertheless, the possibility that settlements involving only non-monetary benefits may be exclusive suggests that the court should be especially cautious in reviewing such settlements. Consider here the following. If the plaintiff had sought in its complaint a change in various aspects of the firm's corporate governance to the exclusion of all other relief, including monetary damages, is it not likely that the defendants would have settled immediately? Assuming the answer is yes, then perhaps the corporate defendant should only have to pay for the value of the benefit, largely ignoring litigation costs of the plaintiff. And the citation for that in 1999. There's a note case here, Goodrich versus E.F. Hutton Group. The court here summarized what continues in 1996 to be the approach taken in awarding counsel fees in action before the federal courts. In the 1970s, courts began to use the lodestar approach to calculate fee awards in common fund cases. Lindy Bros Builders Inc. of Philly versus American Radiator and Standard Sanitary Corp. See report of the Third Circuit Task Force. Court awarded attorney fees from 1985. That method requires a court to calculate the product of the attorney's reasonable hours expended on the litigation and reasonable hourly rate to arrive at the lodestar. Swedish Hospital Court versus the lodestar calculation can then be adjusted through application of a multiplier or fee enhancer to account for additional factors, the contingent nature of the case, and that quality of the attorney's work. And it gives the citation that I already read. So to calculate the product of an attorney's reasonable hours expanded on the litigation and reasonably hour rate to arrive at the lodestar. That's from the Swedish case. All right, so next page, Swedish Hospital. That citation is given. Can't see so well. All right, so during the 1970s, the lodestar multiplier method of awarding fees was frequently invoked in common fund cases. Instead of determining a reasonable percentage of recovery from the fund based on multi-factor analysis. Johnson versus Georgia Highway Express is where you get the reasonable percentage of recovery from the fund based on multi-factor analysis. And then there's another citation, Lindy Bros again. In the 1980s, however, two events led to reconsideration of the lodestar method of calculating common fund fee awards. First, in 1984, the Supreme Court distinguished the calculation of awards under fee-shifting statutes from the calculation of attorney's fees under the common fund doctrine. In doing so, the Supreme Court suggested that an award in a common fund case should be based upon the percentage of the fund, unlike the calculation of attorney's fees under the common fund doctrine, where a reasonable fee is based on the percentage of the funds bestowed on a class. A reasonable fee under Title 42 of the United States Code, Section 1988, reflects the amount of attorney time reasonably spent on litigation. That quote comes from Blum v. Stenson in 1984. The footnote in Blum has been cited for the proposition that the Supreme Court's approval of the lodestar method in the fee-shifting context was not intended to overrule decisions which had approved percentage of the fund awards of attorney's fees in common fund cases. Where was I? Okay, just give me a bunch of citations. The interpretation of Blum did not change when the Supreme Court held that the lodestar should not be enhanced through the use of a multiplier in statutory fee-shifting cases. City of Burlington versus Daig, 1992. The second significant event of the 1980s was the report issued in 1985 by a task force of the Third Circuit had appointed to evaluate the practical effectiveness of the lodestar method in making attorney fee awards. See report. The task force recommended continued use of the lodestar technique in statutory fee shifting cases. See Burlingame again. Acknowledging in the statutory fee shifting context a strong presumption that the lodestar represents the reasonable fee. The task force concluded, however, that all attorney fee awards in common fund cases should be structured as a percentage of the fund. Report of the Third Circuit Task Force Court awarded attorney fees. At the present time, the majority of the federal courts use a reasonable percentage of the fund method when making attorney fee awards in common fund cases. See Swedish again. See also Federal Judicial Center awarding attorney fees in managing fee litigation, canvassing case law. The Third Circuit has recently held that the percentage of the fund generally is generally the preferable method for awarding fees in common fund cases. But noted that a lodestar analysis might be used to cross-check the propriety of the award, a hybrid approach. See in General Motors Corp. Pickup truck, fuel tank products, liability litigation. Ultimately, however, the Third Circuit permits the trial court to exercise its discretion in choosing whether either court discretion and the choice between the percentage method or the lodestar method or some combination or hybrid. And as the circumstances warrant in making common fund awards. Section 11, security for expenses. You see in the New York Business Corp Law, it's Section 627, California Corp Code, Section 800, Securities Act, Section 11E and 27C, and Securities Exchange Act, Section 21D3C, And the last case in this chapter is West Hills Farms versus RCO AG Credit Inc., California Court of Appeal, 5th District, 2009. Kane delivered the opinion. In this derivative action, defendant RCO Ag Credit Inc. was sued by two of its shareholder plaintiffs West Hill Farms, Inc., the California Pistachio LLC, based on allegedly unnecessary fees paid by defendant to related corporate entity. Defendant made a motion under Corporations Code Section 800 to require plaintiffs to furnish a bond in the amount of $50,000 as security for defendant's anticipated litigation expenses to defend the action. The motion was granted and plaintiffs furnished the required bond. Defendant ultimately prevailed in the action and following entry of judgment moved for an award of all the attorney's fees and costs incurred, totaling over $350,000. The trial court's order limited the award of attorney's fees and costs to $50,000, the amount of the bond. Defendant appeals from that order, contending that under Section 800, it was entitled to recover all of its attorney fees and costs, regardless of the amount of the bond. We disagree. Accordingly, we affirm the trial court's order. Section 800 addresses the terms and conditions under which a shareholder derivative action may be maintained. The statute includes a provision at issue here that a plaintiff shareholder may be compelled to furnish a bond as security for a defendant's anticipated litigation expenses, including attorney fees, which may be incurred in defense of the derivative action. This is a quote from the rule, purpose of the section bond statute is to create a deterrent to unwarranted shareholder derivative lawsuits by providing a mechanism for securing and prevailing defendant's expenses up to $50,000. See Donner Management issue for 2006, California App. According to statute, the defendant corporation's motion to require a bond will be granted on a showing that there is no reasonable possibility that the prosecution of the cause of action alleged in the complaint against the moving party will benefit the corporation or its shareholders. Additionally, the same relief will be extended to a defendant who is an officer or director of the corporation if it is shown in that said moving party, if other than the corporation, did not participate in the transaction complained of in any capacity. Subdivision 8 of Section 800 sets forth the particulars and the relief afforded by the motion as follows. At the hearing upon any motion pursuant to Subdivision C, the court shall consider such evidence as may be material to the grounds or grounds upon which the motion is based, or to a determination of the probable reasonable expenses and attorney's fees of the corporation which will be incurred in defense of the action. If the court determines, after hearing the evidence adduced by the parties, that the moving party has established the probability in support of any grounds upon which the motion is based, the court shall fix the amount of the bond not to exceed $50,000 to be furnished by the plaintiff for reasonable expenses, including attorney's fees, which may be incurred by the corporation in connection with the action, including expenses for which the corporation may become liable pursuant to Section 317. The ruling by the court on the motion shall not be determination of any issue, any action, or of the merits thereof. If the court upon the motion makes a determination that a bond shall be furnished by the plaintiff as to any one or more defendants, the action shall be dismissed as to the defendant or defendants unless the bond required by the court has been furnished within such reasonable time as may be fixed by the court. Aside from this bond protection, however, Section 800 makes no mention at all of attorney fees or expenses. Indeed, the only references in the statute to attorney fees or other expenses are within the limited context of describing what the bond will secure. There is simply nothing in the language of Section 800 to suggest that the legislature intended to create an independent basis for recovery of attorney fees or costs apart from the recourse of the bond. Of course, the legislature is quite capable of drafting statutes that authorize awards to prevailing parties of all reasonable attorney fees or costs incurred in an action without limitation here. However, the legislature did not do so. All right, so background note on security for expenses statutes. Security for expenses statutes must be considered against the background of this general American rule that the losing party in the lawsuit does not have to pay the winner's expenses except for taxable costs, such as the clerk's, witnesses, dockets, and transcript fees. Accordingly, security for expenses statutes are normally not interpreted to impose individual liability on the plaintiff for expenses, that is, liability beyond the amount of the bond. A shareholder who wants to bring a derivative action in a state that has a security for expenses statute is under heavy pressure to find some way to bring suit without posting security, since the statutes are normally interpreted to be inapplicable to direct as opposed to derivative actions. One alternative is to frame the suit as a direct action. The second alternative is to bring the action under some provision of federal law, such as the proxy rules or Rule 10b-5. The security for expenses requirement may also be avoided in certain types of cases by petitioning for a dissolution or the appointment of the receiver. And that comes from Liebert vs. Calap and New York. So there's 3 more pages of Section 12, private ordering and shareholder suits. Consider the policy implications of the contemporary debate on the efficacy and desirability of articles of incorporation or bylaws, including provisions that either require inter-firm disputes or be arbitrated or litigated only in the courts of a specific state, forum selection provision, and typical forum selection bylaw powers the board of directors to choose between the favored forum, example Delaware, set forth in the document, or choose among the forums in which the suit is pending, in which a shareholder can proceed. Suit can proceed. Forum selection bylaws were upheld in Boilermakers Local Retirement Fund versus Chevron, Delaware, 2013. Chancellor Shrine held that Section 109 of Delaware statute empowers boards to adopt forum selection bylaws. Title 8 of Delaware Code, Section 109, has long been understood to allow the corporation to set self-imposed rules and regulations that are deemed expedient for its convenient functioning. The forum selection bylaws here fit this description. They are process-oriented because they regulate where stockholders may file a suit, not whether a stockholder may file a suit or the kind of remedy that the stockholder may obtain on behalf of herself or the corporation. The bylaws also clearly address cases of the kind that address the business of the corporation, the conduct of its affairs, and the rights or powers of the stockholders, directors, officers, or employees, because they govern where internal affairs cases governed by state corporate law may be heard. These are the kinds of claims not central to the relationship between those who manage the corporation and the corporation's stockholders. Furthermore, Boilermakers deployed the view that the company's bylaws are part of the web of contracts that can limit rights shareholders may otherwise have. In an unbroken line of decisions dating back several generations, the Supreme Court has made clear that the bylaws constitute a binding part of the contract between the Delaware Corporation and stockholders. Stockholders are on notice that as to those subjects that are subject to regulation by bylaw under 8 Delaware 109B, the board itself may act unilaterally to adopt bylaws addressing those subjects. Such a change by the board is not extra contractual simply because the board acts unilaterally. Rather, it is of the kind of change that the overarching statutory and contractual regime the stockholders buy into explicitly allows the board to make on its own. In other words, the Chevron and FedEx stockholders have assented to a contractual framework established by the DGCL in the Certificates of Incorporation that explicitly recognizes the stockholders will be bound by bylaws adopted unilaterally by their boards. Under that clear contractual framework, the stockholders assent to not having to assent to board adopted bylaws. The statutory regime provides protections for the stockholders, though the indefeasible right of the stockholders to adopt and amend bylaws themselves by its terms, Section 109A, vests in the shareholders a power to adopt, amend, or repeal bylaws that is legally sacrosanct, i.e., the power cannot be held consensually eliminated or limited by anyone other than the legislature itself. Thus, even though a board may, as is the case here, be granted authority to adopt bylaws, stockholders can check that authority by repealing board adopted bylaws. And of course, because the DGCL gives stockholders an annual opportunity to elect directors, shareholders have a potent tool to discipline boards who refuse to accede to a stockholder vote repealing a form selection clause. As a corporation's bylaws are part of the inherently flexible contract between the stockholders and the corporation under which the stockholders have powerful rights which they can use to protect themselves if they do not want board adopted form selection bylaws to be part of the contracts between themselves and the corporation. And as noted, precisely because form selection bylaws are part of the larger contract between the corporation and stockholders, and because bylaws are interpreted using contractual principles, the bylaws will also be subject to scrutiny under the principles for evaluating contractual form selection clauses established by the Supreme Court of the United States. And the Bremen versus Zapata Offshore Co. and adopted by our Supreme Court in Bremen, the court held that form selection clauses are valid provided they are unaffected by fraud, undue influence, or overweening bargaining power, and that the provisions should be enforced unless enforcement is shown by the resisting party to be unreasonable. Subsequent to Boilermakers relying on the contract orientation that emphasized in Boilermakers, the Delaware Supreme Court held that a non-stock Delaware corporation's board of directors could adopt and enforce a bylaw that shifted the defense's litigation costs to the plaintiff when the suit was substantially successful. ATP Tort Inc. versus Deutscher Tennisbund, Delaware, 2014. It should be noted that Delaware non-stock corporations, although not having stockholders but members, are subject to the Delaware General Corporation Law. To some extent, Boilermakers have now been overtaken by legislative developments, at least in Delaware. In 2015, the Delaware legislature amended the Delaware General Corporation Law to expressly authorize form selection bylaws. Last page. But the same legislature acted to prohibit fee-shifting provisions such as was involved in ATP Tour, which prohibits a provision in the charter, and by virtue of Section 109, a fee-shifting provision is also prohibited in the bylaws. Neither provision addresses another lurking development, bylaws calling for shareholder disputes to be arbitrated. Arbitration. See Ann Lipton, secondary source, 2019. Commentators have also challenged the contractual basis for provisions affecting shareholder litigation via unilateral action by the board of directors. See James D. Cox, another secondary source from 2015, and another one from 2014, another one from 2013. A separate concern is the scope of such litigation-focused bylaws. For example, Shia Petrucci versus Salzburg, Delaware, 2018, considered the validity of a provision in the Articles of Incorporation providing that any securities fraud claim under the Federal Securities Act involving an alleged misrepresentation in the firm's prospectus that's used in an IPO must be brought in federal court. Unless the company agreed in writing to suit in state court. The FSA provides, and that's the Federal Securities Act, that federal and state courts have concurrent jurisdiction over such suits. The court held that sections 102B1 and 109B of the Delaware statute do not authorize charter or bylaw provisions to regulate external relationships such as the purchase of stock. The court held that the statute only reaches matters and relationships internal to the corporation. Query could a board adopt a bylaw that requires a certain number of shares to be owned to initiate a derivative suit? How about a bylaw that conditioned the plaintiff initiating any kind of shareholder suit to post a bond to secure the defendant's litigation costs? Sounds like it should be limited to $50,000. Kidding, that's the end of this